Judge, it'll be on the 4th floor at the court administrator's office.
4th floor.
All right. Judge Allred, we're here to hear you.
Massey exhibits D and E.
Ladies and gentlemen of the commission,
I first want to start by saying thank you for your time. I know you have families, and I know this is the upcoming Labor Day weekend, and to be quite frank with you, I'm ready to go too. And it's my desire to take my wife and kids and head out of town as fast as I can. And I hope you do the same. And I appreciate your time with all my heart. It is important, though, that I have the opportunity and had the opportunity to state my side of the case. I want you to understand why things happen from my standpoint. And I want you to listen to Respondent's Exhibit E that was entered. This is an email sent from Henry S. Johnson, Martin Lipper, to the CC, Judge Grisham. I won't be back in Harlem until late next week. I'm going to be jet lagged. So you and Joe need to pick this up and run with it. I know you were both campaigning, but by now the primary is either won or lost. Letting Russ succeed with the special grand jury discrediting us could be a big impact on the general election. Spending time on this will probably do more to ensure your re-election than shaking a few hands. Please let me know everything. Henry. Those aren't my words. Those are the words of a key witness in this case. If you go back and look at the record, the very first person that Gene Weaver talked to was Henry S. Johnson. If you look at his statements, it was almost like a laundry list of things for him to go and see. That's what it was. It was a laundry list of everything under the sun. And a lot of it turned out to be nothing. And it was done for purely political reasons. Has it been my position throughout this that politics did play a role in all this coming around? But the politics weren't from me. The politics were from a sheriff that you heard sit right there in that witness stand, in my opinion, lie. Bold-faced lie to you. He was asked if he discussed the confidential investigation of Joe Grisham with specific individuals. He said no. 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 As soon as I could get him in this courtroom, let him testify, you heard from those three individuals. Yes, he did. One of them was a judge executive candidate, Sean Miller. Remember what Sean Miller said? He said the sheriff called him to his office at the courthouse, took him in the back room with Bill Ball, and they were looking for allegiance to the chaplain's corps. Now, you've heard a lot about the chaplain's corps. The chaplain's corps is the political arm of the sheriff's office. After Sean Miller was talked to in the sheriff's office about the chaplain's corps, he was taken outside by the sheriff and told, we're going to indict Joe. We've got it. We're going to indict him. We're going to indict Judge Executive Grisham. What other reason would a sheriff have for telling Joe Grisham's political candidate, a political opponent, than for pure politics? That wasn't enough. I heard Jonathan Poland, the elected magistrate in Harlan County, testify that while he was working his job before the primary, he gets paged to the hospital the sheriff is out there. The sheriff starts talking in very, I'm trying to think of the term he used, but it was in such a way that it made he didn't want people to hear what he was saying in the sense of it being kind of crude. So he stepped outside. And the sheriff said, don't worry about your election to that effect. You just win the primary, you'll be in there, because I'm going to take Paul Caldwell down. I got him and Joe trading sex for pills. Now that's a conversation of the sheriff to another candidate in Harlan County. Crowley Forrester testified in here. He's recently retired to come back to Harlan County. He's been a customs agent for many, many years in Florida. He comes back here and testifies. When he asks the sheriff about a potential employment person to talk about employment, the sheriff says, and he mentions Joe Grisham. Don't see Joe Grisham. So he's done. We're going to indict him. He won't be reelected. We got the goods on him. Trafficking drugs. Seeking pace. The sheriff said that. Not one time in this entire hearing did you ever hear anybody say that Judge Russell Allred mentioned this to anybody. Not once. Not one time. Newspaper articles, there's nothing in there from me. You know why? Number one, the Lord told me it was a good thing not to do. Don't get involved in that. Don't try to get out there and sling mud with it. The other reason is, I got an ethics opinion that told me, keep your mouth shut. And I did what the ethics opinion told me to do from the ethics committee. It went on, and as time went on with this thing, it became very evident that the grand jury was used and the investigation was used by the sheriff's department for purely political means. It became evident from these emails to me that this whole thing was pushed by the Commonwealth Attorney while he's in Scotland sending emails like this. Emails that have no legitimate purpose, even though he tried to say it was something legitimate for the Commonwealth Attorney's office. Things like, I'm in Scotland until late next week, so it won't be easy. This is Exhibit D. I'm in Scotland until late next week, so it won't be easy for me to do this. Please get the information together, keep in touch, and let them know how things are going. Unless you have heard from WYNT and the Enterprise, I would not assume they're going to do anything with the story about the affidavit. I think they're too timid to touch it. I hope I'm wrong about that. It may be necessary for you to arrange a press conference with as many media reporters as possible, including the Lexington paper, and let all this out. My office staff is preparing information packets on the James Howard hearing, the Dr. V orders, and making them available to the press. What legitimate purpose could be served by the Commonwealth Attorney using his staff to send media packets out to the media? The answer is politics. I told you all when I first saw you all many months ago that this was politics. And I told you all some very bizarre scenarios, and I'm sure you all thought that I was a nutcase when I mentioned those. But as it turns out, that's the scenario that happened in this case. The sheriff was telling people about this, using his investigation for his own political purpose. The Commonwealth Attorney was orchestrating it behind the scenes. And I had to sit back and deal with all the results of the political action. Let's go to count one. Regarding Mr. Johnson, telling you to get all the money or I dismiss it. Just didn't happen. Not true. Didn't happen. The facts of the case lay that out for you plainly. There was $1 million as part of that agreement. $200,000 was still there with it. 1.2 was the bond at the end of the case. $200,000 went to the doctors, back to them, approximately. And prior to that, $200,000 earlier dollars had gone back to the doctors. So, on its face, that's not true. Secondly, it never happened. In regard to the allegation that I would dismiss it for lack of jurisdiction, look at the record. I overruled a motion to dismiss it for lack of jurisdiction in October. It's there. In regard to Wallace Smith, I want to tell a little bit about Wallace Smith. That never happened with Wallace Smith. That never happened. I never pressured or forced the sheriff to investigate Wallace Smith. Wallace Smith was probably one of the largest drug dealers the sheriff ever busted. That's reflected from the file that showed the number of pills and the criminal syndicate he was in. The problem there is the sheriff's best friend, Bill Ball, was a close personal friend of Wallace Smith. You heard him testify that he's selling gold coins on the internet for him to the tune of $1,500. Doesn't that kind of give you some pause to wonder what a chaplain in the sheriff's office is doing selling gold coins for a drug dealer? Give me pause. And it happened. Bill Ball came into my office with the sheriff and tried to ex parte me about that case. And I threw him out of my office. That wasn't enough. He called me on the speakerphone several months later and tried to have me ask me on the speakerphone. Remember when you told me you probate this person, Judge? I said, nope, I don't know what you're talking about. The simple fact of the matter is, that's what happened in that case. Nothing else. Wallace Smith was trafficking in drugs. He was part of a criminal syndicate, and the sheriff had to bust him. It's my belief that the community was talking about it, that they knew this man was a drug dealer, that he was part of this criminal syndicate where somebody else had come along in this. But I had nothing to do with Wallace Smith being busted. Wallace Smith was busted, as you can see, because he was part of a criminal syndicate trafficking in drugs. The problem arose because that was Bill Ball's friend, a friend that he'd sold gold coins for. It's on the internet. You heard my testimony and the rest of these things. I want you to think about something, though. This was probably the most bizarre thing that happened this entire hearing. I'm going to shut up. I'm not going to use my whole 45 minutes. I'm not going to waste your time. But the most bizarre thing that I've ever seen, and almost in my life in a legal career, is watching the judge executive, who was the subject of the special grand jury, testifying on my behalf, vehemently cross-examined by the JCC attorney. Vehemently cross-examined. And that was bizarre to me, because he was the subject of the special grand jury. He is technically the victim of a situation like that, as it turned out to be. And he was here testifying on my behalf. What possible reason would he have to lie? There is no reason. The reason the judge executives gave a statement in May making certain allegations, and the reason you never saw another one was these emails. Those emails I read you. How would you feel if the Commonwealth Attorney was sending you emails and telling you that the city circuit judge is going to indict you? This special grand jury. We got to get him before he gets us. How would you feel? How would you? That's just what we saw in email. I don't know what I was told the man. How would you feel if a newspaper reporter brought you to her office out there, showed you a copy of the special grand jury order, and said Judge Allred gave me that order? And you know what? That was another lie. Because I hope you all caught it, because the special grand jury order was given to that reporter by Henry S. Johnson, who called the Enterprise and had her come down to his office, and he gave it to her. Now, the judge executive figured this stuff out on his own. There's some kind of insinuation that I've talked to him a whole bunch of times. Well, I'm defending myself. He's a witness. How many times did Gene Weaver and George Robbie talk to Joe Grisham? How about the last time we talked to him, we went in his office, and he was very upset, and adamantly so, because he had figured things out and knew that the sheriff was out there spreading this stuff all over the place about special grand jury, writing about we'll put him in jail, and using his office for that purpose. And he tells the investigator for the Judicial Conduct Commission, with the lawyer for the Judicial Conduct Commission sitting in that room, he tells them, I'm recanting what I've got. That's his testimony. I'm recanting what I said before. These fellows are the problem. And then what does the Judicial Conduct Commission investigator that's paid with state funds do in that case, Mr. Chairman? What does he do? He offers to try to help to get the sheriff to apologize to him. And he tells him that the Commonwealth attorney was just trying to help him. Now, I wonder how many witnesses that said something negative about me got the same treatment from Mr. Weaver. I venture to guess you never see that anywhere. I'll tell you something else that's odd, too. I wonder why there was never a statement sent to the Judicial Conduct Commission each time, or at least a report each time that Mr. Weaver met with Judge Grisham. Why? Shouldn't you get the report? If you're paying them to drive down from Covington to Harlan, shouldn't you know if it's worth driving from Covington to Harlan? Shouldn't you have a report of what it was about? You look in that record to see how many statements came from Joe Grisham. That's the thing that bothers me the most. And you heard Joe Grisham. He requested you dismiss the allegations of special grand jury. He said I did the right thing. I did what I was asked to do. I didn't start this investigation. I didn't choose when it started. I didn't choose when it ended. I did the best I could under the circumstances. Because you know what? I believe people were honest. I believe the sheriff was pretty honest. I believe he was probably trying to do a good job. I believe Mr. Johnson was pretty honest. I would have never dreamed in a million years he would have sent emails to somebody like that. Never dreamed. You heard his own testimony. Okay, I went over the top. Went over the top. But because the sheriff decided to play politics with the investigation, because the Commonwealth attorney got mad and went over the top, well, that's what I believe. And when I saw those emails, I knew exactly what I had said and believed happened did in fact happen. It was an orchestrated effort to try to destroy me, to get as many people as you can to make allegations. And I don't have to go into all the allegations that were in this thing, but it went on and on and on and on. Y'all got tired of seeing me. I don't doubt it. And to be honest with you, I promise you I didn't want to drive down to Lexington and see you all. And if I had a dime for every time that me and Whitney stayed up the night before we had one of these meetings, I could retire. But anyway, I just want you to take that away from me. And I want you to listen to a holding, to a ruling from the court. In the Nicholson case, of all cases, the one that upheld the constitutionality of what you all do here. But in this case, it says, citing on page, I'm a page here. Back over the other page. 644. A busy trial judge must rely on some degree on the competence and integrity of the attorney regularly appearing before him. I mean, I'm only as good as the people that are around me. I have a job to do. And the way I liken this is if my job is to cut the trees down, and somebody's job is to pile them up, cut them up, and haul them off, I can't keep the trees moving if somebody over here is not cutting them up, sawing them up, and hauling them off. Or if they're telling me we need more trees. I mean, I have to work with people. And my job as a judge is only as good as what I'm presented with and the people that are around me that present me this information. I did what I believe was right. And I still believe to this day that what I did was right under the circumstances and what I knew at that time. Knowing what I know now, the door would have never been opened. I would have ran like a scalded dog out of there as fast as I could. I want you to take this away from this too. In the Nicholson case, it says, none of Judge Nicholson's conduct was directed toward personal gain, but was, according to his evidence, motivated by a desire to prevent what he perceived to be potential destruction of an individual's rights. Kofa Hudson's case, that's it. That's what I believe with all my heart. Not one bit of animosity toward Kofa Hudson. Frustration, yes. Is it wrong? Is it unethical for a judge to be frustrated? No. Who isn't frustrated? What do I do? When the Constitution of the United States of America says that no person shall be deprived of a right to an attorney. What do I do? What do I do when I have 250 and 300 people on a certain docket, on a criminal docket, and an attorney that always calls in sick, Well, it's always roads are too bad down her way. What do? I've asked the supervisor to help me. Do I put her in jail? Does that alleviate the problem of no attorney? In fact, now there are attorneys in jail with them. They still have no attorney to represent them. What I do is the most expeditious way that I can, I direct that attorney, the managing attorney, to get me an attorney in here that can take care of this problem. Represent me. And it happened. I can't tell you how happy I am it happened. If it hurt Ms. Hudson's feelings, well, I'm sorry it did that. But the Sixth Amendment rights of those defendants is paramount to Ms. Hudson's feelings, my feelings, or anybody else's feelings for that matter. And then in the Nicholson case, and I'll read you this, remember this. The judge by the attendant publicity has already paid the penalty for his mistakes. I can't tell you how much publicity I've had out of this. Quite frankly, I'll be glad when all this is over, one way or the other, and we can try to get back to a resemblance of our life. I can tell you right now that I have no animosity for anybody that did any of these things that I believe happened to them from the other side. I forgive them right here and now in this courtroom. I forgive them. As a born-again baptized believer, I have to forgive them, and I do forgive them. And I have no animosity toward them. I don't want to see anything bad happen to them. But that doesn't change what I believe happened. That doesn't change what I believe was shown in this hearing. And while I'm on this issue, I want you to understand that at no time in any of this, and I know people tried hard, they tried so hard to make it look like I was trying to do something for myself. I know this record. I know what it was. I know what was trying to be said about me. And that was the most hurtful thing in this entire situation. If I made a mistake advocating for a water park as a private citizen at the fiscal court meeting, well, look at what I was doing. I wanted the children of Harlan County to have something so they would be off drugs. Something else besides getting on drugs. See a smile, see a laugh. I know now, as a judge, like Judge Keller says, those days are over. You can't go with it. Even though the rule says you can go in there as a citizen of your own personal emotion. Well, that's just, you just walk into a guillotine. That's all you're doing at that point. And I can assure you that I have not, nor will I ever go back to another fiscal court meeting as long as I am a judge. And I can assure you that I have always paid deference to this committee. I will point out that I believe that I have established by the evidence in this case that my actions were always done in good faith, and I believe all of them, except for the playground fundraising, as I've already admitted, were in compliance with the standard that I must uphold as a judge. The playground issue, I conceded that early on, and I still do. And I can assure you I'll never raise money for a playground again, as long as I am a circuit judge or a district judge or a court of appeals judge or judge on the Judicial Conduct Commission or maybe judge the beauty pageant, maybe, but not as long as I am a sitting judicial officer of this state. I thank you for your time, and I have no animosity towards you all. I don't. So if I'm going to train somewhere as Judge Coleman, say hello. If I see you somewhere, say hello. I'm not Judge Johnson. If I see you, say hello. Jim Wojcik, if I see you, say hello, because I have no animosity. And anything I filed in this record, I did to perfect the record for my defense. And thank you for your time.
Thank you, Judge Allred. Make sure, I think, Mr. Majors and you will get together. Don't worry about it. You don't need to do it right now unless Mr. Mando needs them, but we've got to make sure we keep the record clear.
Thank you.
I need to see the grades of those myself.
And were there two, did you get the two exhibits? Okay. Mr. Mando.
Mr. Chairman, members of the commission, Judge Allred.
Mr. Mando, I apologize for not addressing you when I started. Sorry.
No problem, sir. On behalf of Mr. Robbie and Mr. Kelly and myself, I too want to thank Mr. Chairman, members of the commission for your time and attention to us over the course of the past 2.5 days. We sincerely appreciate it. We recognize and appreciate the role you play in our judicial system in this state. What we have presented for you over the course of the last day and a half in our presentation is a case where we have 13 counts of the violation of the Code of Judicial Conduct. I believe that the evidence has shown you in this particular case that Judge Allred has disregarded that code. He's disregarded the law, and on certain counts he's abused the power of his office. As I told you at the beginning of this presentation, of this hearing, a number of the facts in this particular case really were not going to be disputed. And I think that the evidence has shown that. There are a few counts where we do have some factual disputes. Count 1, Judge Allred denies that he threatened to dismiss the case for lack of jurisdiction. Sheriff Lipford and Commonwealth Attorney Johnson both state that he made such a statement in Henry Johnson's office. There's also a factual dispute with James Howard. Sheriff Lipford said that he was pressured by Judge Allred in order to investigate and remove the gaming machines that were in Mr. Howard's gas station. Judge Allred says, yes, I contacted the Kentucky State Police about those complaints. I think today I heard him say that he may have given some details about those complaints, but he has no recollection of talking with Sheriff Lipford. With respect to Wallace Smith, that's the other count where we have a factual dispute. With Wallace Smith, Sheriff Lipford told you that he was pressured in order to investigate and have Mr. Smith indicted. Judge Allred denies that. Those factual disputes, of course, will call for you to make some credibility determinations on those specific counts. But for the other 10 counts, I submit that what you heard and the documents that have been introduced and hearing evidence show that certain facts, key facts, are undisputed and establish the validity of these particular charges. With regard to the donated funds to the Harlan County Fiscal Court, while there is a factual dispute based on this record as to whether Judge Allred threatened Mr. Johnson and Sheriff Lipford to dismiss the case for lack of jurisdiction if the money was not to remain, all of the bond money was not to remain in fiscal court or in Harlan County. There's a certain ring of truth to what Commonwealth Attorney Johnson said and what the sheriff said. And a ring of truth is at that same time, this is undisputed, Judge Allred wanted that money for a water park for Harlan County. So if you think about the context in which Commonwealth Attorney Johnson and Sheriff Lipford said that, there's a motive that says, yes, maybe Judge Allred did say that because he wanted to make sure that that bond money, all of it, stayed in Harlan County. That particular order, this plea agreement that was approved on January 11th of 2010, provided that $500,000 was going to be donated to the Harlan County Fiscal Court, and according to the order, to alleviate drug abuse in Harlan County, with the use of those funds subject to the approval of the Harlan Circuit Court, which is Judge Allred. That particular plea agreement was discussed. Its terms were outlined in open court according to the DVD of the hearing that we presented. The order reflects those terms. It was entered on January 11th of 2010. Then we go to the fiscal court meeting on January 19th. And at that particular fiscal court meeting, Judge Allred appeared before the fiscal court, and the $500,000 quickly became a big topic of discussion at that meeting. And in that particular meeting, Judge Allred, I submit, was not speaking as a citizen. He was speaking as judge. And he was outlining how he had control and ultimate veto power over those particular funds. We've introduced the transcript of that fiscal court meeting. But at that fiscal court meeting, and I think Judge Allred acknowledged most of this on cross-examination, he acknowledged, and this is Judge Grisham asked him, the chaplain corps approached me and asked me if there could be some of that used for their program, which Judge Allred stood up and interrupted and said, Judge, I would object wholeheartedly. Absolutely not. I did retain the court's ability to veto something like that. This money is for the youth of Harlan County. It's not for the chaplain's corps. While Judge Allred's motives in terms of where he wanted money to go may have been noble, it exceeded the bounds of what a judge can do, lending the prestige of his office and the power that goes with being a judge in terms of influencing that fiscal court. When he was specifically asked about the language in the order, he said, I can approve. I can veto anything that goes out of that domain that you have in there, youth programs and facilities. He specifically said, when asked further about it, now, if there's ever a suggestion that we can carve this up to the chaplain's corps or some other group not related to the juveniles, number one, it's illegal. Number two, there's a court order giving me absolute veto over that. That does not sound like the speech or petition of a private citizen. That's a judge using the power of his office to control the $500,000 that was in the hands of the legislative body in Harlan County, the fiscal court. After his presentation and speech before the fiscal court, he received a letter from Jim Lawson at the Judicial Conduct Commission advising that he had received 2 complaints about what had occurred. Number one, with the newspaper account about the veto, about the Harlan Circuit Court controlling the use of these funds to alleviate drug abuse in Harlan County. And number two, about his statements before the fiscal court about veto power and asking him, what authority do you have to do that? Judge Allred then sent a response, and in addition, he went back and he put on an amended order dated January 11, 2010. He said, I'm sorry, I misspoke. The title of his order, amended order, dated January 11, 2010, was actually entered in the Harlan Circuit Court on March 11th of 2010 after he had received the Judicial Conduct Commission letter from Mr. Lawson. And in this particular order, he says that the order dated January 11, 2010 is hereby amended to reflect that the language, quote, with the use of these funds to be subject to the judge of the Harlan Circuit Court, close quotes, is hereby removed. The remainder of this order is left unchanged. And this is the important part from the purposes of these charges. This language was inadvertently put into this order by counsel for the defendants in the Commonwealth Attorney's Office. It was neither solicited nor approved by this judge. I submit that that's a misrepresentation. We've got the DVD of the hearing where he was told what the terms are and he approved it. We've got the order that he entered on January 11th stating what the terms of that particular plea agreement are, which says that he retained control over the use of those funds. We've got his presentation at the fiscal court meeting on January 19th in which he explained his veto power to the fiscal court. For a judge then to put on this type of order to say that this was neither, that he did not approve this language and that it was inadvertently put into the order by the Commonwealth Attorney and the defendants is a misrepresentation. With regard to the Grisham special grand jury counts, in this particular case, it's undisputed that Judge Allred did look at and view videotape evidence that was secured by the sheriff's office during their case, during the investigation of of Judge Grisham. According to Winston Erie, he even alerted Judge Allred to a concern. He said, "Judge, should you be looking at this?" Raising this issue of a conflict. Judge Allred said, "It's not a problem." And he went ahead and he looked at that video evidence. And then later, of course, after he's looked at that video evidence, after he's seen that, discussed the matter with the sheriff and with Deputy Erie, he then issues the special grand jury order on March 22nd of 2010. Judge Allred goes to great lengths to explain that this was all set up, that this entry of this order on April 22nd, 2010 was part of a grand scheme or a design plan by the Commonwealth Attorney in cohorts with the sheriff to try and set him up. The evidence doesn't support that. What I have before you and what we presented before you are some undisputed facts that are pretty compelling. We know that before that order was entered on April 22nd of 2010, that Judge Allred knew that his cousin, Denny Pace, was running for judge executive in the primary with Judge Grisham. Undisputed. We know that he had a conversation with the Commonwealth Attorney a number of days before the order was entered in which they discussed convening a special grand jury. When they discussed the investigation, according to the Commonwealth Attorney, he made sure that the judge knew that this was going to be a no true bill because Ms. Hensley was not credible, because the Attorney General had indicated there was no evidence to support this particular charge, and that the videotape evidence was inconclusive at best. Judge Allred knew that, according to the Commonwealth Attorney, and Judge Allred even acknowledges that he had a conversation with the Commonwealth Attorney when they talked about convening this particular grand jury. Now, what then tips the balance? What causes this order to be entered? Because there's no hurry. There's some rumors going around, but nothing huge. What happens? April 22nd of 2010, there's a hearing in the morning on Judge Allred's docket, Potter versus Howard. And in Potter versus Howard, there's a motion to recuse filed by Mr. Howard. He sets forth a number of grounds in his written motion, which we've introduced into evidence, stating why Judge Allred has a conflict and should recuse. Judge Allred considers those grounds, the fact that James Howard politically supported Judge Johnson, the fact that Judge Allred had been counsel for some parties in litigation in which he was a defendant or adverse party. And Judge Allred dismisses the motion on those grounds. Whereupon, according to the DVD that you had, Mr. Howard presents this affidavit from Judge Grisham. And this affidavit from Judge Grisham, which was the subject of testimony yesterday from Judge Grisham, indicates that he was summoned to Judge Allred's office, that Judge Allred asked him about this property that the Industrial Development Authority owns. It formerly housed the Sunshine Biscuit Factory. And he asked whether or not it was feasible for the county to retain control of this property for Mr. Howard. According to this affidavit, according to the conversation the statement that he gave, that Judge Grisham gave to Mr. Weaver, which we came into evidence yesterday through cross-examination, they wanted it, Judge Allred wanted it for purposes of establishing this drug lab that he was going to own or somehow be a part of. And when Judge Grisham said, we can't do anything about that, he said in his affidavit, Judge Allred became quite upset, agitated. So, the DVD shows when this affidavit was presented to Judge Allred, he looked a little perturbed. If you look at his facial expressions on the DVD, and he immediately says, we're going to hold a hearing, and I want Judge Grisham coming in here. And he gets up. So what does he do later that day? After he's seen this affidavit from Judge Grisham, which he testified, Judge Allred said, as soon as I read it, I knew it was false. So he knows it's false. He sees it, and what does he do? That same day, he enters that special grand jury order. I think Judge Grisham kind of said it best in his statement to Gene Weaver, which he acknowledged on cross-examination the other day, the statement that he made to the paper that's been admitted into evidence. The timing of it all made sense. It doesn't take a great deal of logic.
Objection. You recanted that. His testimony was he recanted that statement.
His testimony was the testimony.
So Judge Grisham says that the timing of it all made sense. He tells that to the reporters. He's saying he was a victim here. All right? And it does make sense. So Judge Allred enters this order, the special grand jury order, and he does so by specifically identifying the target for the purpose of looking into drug sales going on out of the Harlan County Judge Executive's office, and files that as a matter of public record with the circuit court clerk. Now, Judge Allred maintains that it was filed there, but nobody could get it. It's an administrative order. But he agreed with me it was a public record. And we know from the evidence that it was released. Over the weekend, we introduced into evidence the email chain which described this order. It had been released. And it was released before the Commonwealth Attorney ever saw it, and before the Commonwealth Attorney ever gave a copy to Ms. Sizebore on that following Monday. I find it hard to believe a couple of things that Judge Allred said. He said that politics in Harlan County, let me get this right here, said specifically, people can get killed in an election year. People die in Harlan County because of politics. So he's aware of all this. And then he says, and this is a quote of his testimony, the thought never entered my mind that the order would affect the primary? Instead, he tries to throw the Commonwealth Attorney under the bus for this. I submit that the Commonwealth Attorney in this particular case did what he was called to do. He did his duty. He saw that order of April 22nd for what it was, and he wasn't going to he was not going to let it be used for political purposes. Despite being the Commonwealth Attorney in a county with one judge, despite the fact that he legitimately feared retribution, that he would have to deal with this, he did the right thing. Commonwealth Attorney took this thing to the regular grand jury, had Mr. Grisham undergo a lie detector, and then let the grand jury look at this evidence in this case, everything they had, and they returned a no true bill before the primary election. The special grand jury order, of course, was out there such that it wasn't going to go till the end of May, after the primary election. And there's no doubt that had the Commonwealth Attorney not done his job and stood up for what was right and just in Harlan County, that election would have been swayed differently. Then, on May the 3rd of 2010, when Judge Allred finds out that this matter has been presented to the regular grand jury, he becomes upset. There's no dispute that he called for the Commonwealth Attorney. There's no dispute that an argument ensued in which he yelled at the Commonwealth Attorney for presenting it to the regular grand jury. And why did he do that? He knew it was going to be returned as a no true bill. He knew that because he knew what the Commonwealth Attorney told him beforehand, and the few days before the April 22nd order was entered. Then he revokes the access card for the Commonwealth Attorney to get in and out of the secure part of the courthouse. That fact is not disputed. With regard to James Howard, as I indicated earlier, that's one of those, there's some credibility issues that have to be decided here. But it is undisputed that Judge Allred contacted the Kentucky State Police, that he wanted them to look into these gaming machines that were Mr. Howard's gas stations, and that after he did that, he then presided over the case involving Mr. Howard, and that an order was entered in which those particular gaming machines were seized and confiscated and the funds forfeited. And that was done outside the presence of counsel. Count 5 is Robin Teschon. The facts there, again, are mostly undisputed. She was a substitute teacher working at James A. Kaywood Elementary School, where Judge Allred's wife worked, and where at least one of his children went to school, I believe. James Clem was the principal. James Clem told you that on 2 occasions, Judge Allred contacted him personally at the school and asked him about Ms. Teschon serving as a substitute teacher. First occasion, he says, why is she still working as a substitute? Mr. Clem says, well, she's told us about it. The district says there's no policy saying we can't continue to use her as a substitute. Judge Allred apparently didn't care for that. Maybe he did feel she was in a position of trust. But then he asked, according to Mr. Clem, again about it. Why she's serving as a substitute. And then, when the district continues to use her, because there was no policy or law that said she couldn't do so, Judge Allred then in December of 2009 places a bond restriction saying that she can't substitute teach at James A. Kaywood Elementary School. We submit that that is just another instance of a judge stepping beyond the courtroom and trying to use the influence of his position as a member of the judiciary to force people to take certain actions. Wallace Smith, that's one of the ones where there's just a straight-out factual dispute. You heard Sheriff Lipford's testimony and you heard Judge Allred's testimony about that. One says he was influenced and directed to go after Wallace Smith. Judge Allred says I didn't do that. The public defender count, Ms. Kotha Hudson.